Hi guys, such moving here again. Now, in today's episode, we are going to be spending some time talking about some very important land documents you need to know as far as real estate is concerned here in Nigeria. You must have heard me mention it here and there in our previous episode, but I want to dedicate to this episode explicitly talking about them one after the other. Now, the Land Use Act of 1978, you understand, according to this particular act, the right to own a land, the right to give out, rights on occupancy on any land located within a particular state is vested on the state governor of that particular state, regardless of where you live, regardless of where your ancestor has been, living from time immemorial. That land, as far as you're in Nigeria, belongs to the state governor where that land is located. However, this particular law makes provision for some areas. So where the government does not have immediate need or use for. You understand? So let's say, according to this law now, you can actually divide land into two classes. So number one, you have government acquired land where government has shown immediate, need or use. And then you also have a free land where this type of land, the government allows the community heads of the previous owners to still lay claim on the land and use for whatever need they have, pending when the government shows interest on that particular land. That is to say, globally, generally, the government still owns every land. You understand, regardless the allowances they make here and there. Now, I had to bring you this law to make you understand the first document we are talking about, the certificate of occupancy. Yes, the almighty C of O. It's issued by the governor of that particular state to anybody, and this particular certificate ensures that that particular land is being leased for a period of 99 years. So the period of 99 years, that land is occupied by someone, and that person will be using that land for whatever need or purposes stated on the certificate of occupancy, and the person is expected to be remitting taxes on that particular land. You understand the point? So that is where a certificate of occupancy comes in. Now, also, you can actually process a certificate of occupancy for your own personal land, for your own private land. So you can actually acquire a private land or your father's land, an ancestral land, and and start the process of getting the CFO and eventually get your CFO for your private land. That still is granted, as far as you follow the procedures to get to that extent. So that is one. Number two, in this line, I need to explain something. I've seen some blogs and other people talking about some of these documents, and a gazette is not like crayfish you pick up anywhere or you get when you buy land. No, a gazette is actually a government document that shows a record of government activities on the land within their jurisdiction. You understand? So a gazette is actually, call it a master plan, that is updated and published, once in a while. So it comes out in volumes. Now, what is actually recorded in this book? It has record of government activities on the land, saying all this land belongs to the government, but this portion has been given back to the community in the process called escission. So it has been excised. So a portion of the whole has been given back to the community. So it's more like a master plan showing all the land in the state and where the government has vested interest in, or the government has actually acquired, and some portion from which they've actually given out to communities. So that is what a gazette is. A gazette is not a document that a buyer demands from a seller. No, it is actually a government document, showing all these things. But you can actually apply to get a sample of a page of the latest activity on the state gazette. That is one. While explaining gazette, I talked about escission. Escission too is not a document per se. Escission comes into play when a host community applies to the government to be given back portion of the land the government has actually acquired, in the time past for a specific reason. Most times it comes because according to the law, they make provision when the people complain about expansion, the need for provision of food through agricultural practices. That is to say, the community doesn't have where to farm again, or they don't have enough land for expansion of the next generation coming. So these are just some of the allowances the law made, the grounds on which a station can be given back to the community. So now, when they apply for a decision and the government receive that application, now, and the government starts to look into that particular application, that portion which is identified by the people or which government wants to give out or to consider to give out will now be mapped out, and that area will now be called a cession in process. It does not mean that that land has been outrightly excised or the cession is successful. No, it means the process for a successful cession has ensued, has started, has commenced. You understand the point? So that is where a cession comes in. So, and that is what a cession is. Don't go and buy land that says a cession in process. If it is in process, it is not yet completed. It still belongs to the government. Avoid stories that touch tomorrow. And that is a cession, my friend. Now, the next very important land document you hear about is the deed of assignment or deed of conveyance, as the case may be. Now, when you have this particular document, it is very, very important you go and register. Now, this document, a deed of assignment or conveyance, as the case may be, is a legal document prepared by a lawyer, and that is used to transfer ownership from one person to another. Transference of ownership from one person to another. It is very, very important. You understand? Now, after prepared by the lawyer, you carry out a particular transaction. The necessary people involved, witnesses, sign their signatures, and you have that document. It's very important to go further to the registrar's office to register, Ministry of Land, to register that this transaction was carried out on this land. The land that was previously belonged to Mr. A is now belonging to Mr. B. It's very important. Don't just stop at signing the document and keep it in your house or something. No, you go further to the Ministry of Land to register that particular document. That is when it becomes authentic. So that is deed of assignment or conveyance, as the case may be. Another document you also need is the land survey plan. It is very important. And this survey plan, hold on, is different from your normal provisional plan. No, regardless of who does the survey, whether the registered surveyor, ensure that this particular survey plan is lodged at the Ministry of Land, and then you are given a certificate of deposit showing that this land is actually the red copy, that the record copy of this plan exists at the Ministry of Land. In fact, without this particular record copy, certificate of deposit, you cannot register your title. That is the deed of assignment I talked about earlier. You understand the point? So your registered survey plan is very, very important document you need to know about. Now, others may be talking about the power of attorney. In my previous video, we've talked about the difference between power of attorney and the deed of assignment of conveyance, as the case may be. Just to recap, your power of attorney is actually a document that shows that allows an entity to stand in place of another person on the issue involved, whether land or anything. So power of attorney says, okay, Mr. A will now stand on behalf of Mr. B in this particular transaction, whether not transference of ownership, but standing in place. So you strip the powers to do anything on this land, and then you vest it on another person to carry out decisions on that particular land, not transference of ownership. In some cases, just like in Nigeria, especially southeastern Nigeria, the power of attorney is most times used in place of a deed of assignment, with the provision that title will be changed when you now want to register it at the Ministry of Lands for your title registration. You understand the point? So these are just very few land documents I think every one of us should know about. And at this particular point, I hope I've been able to enlighten you and not to confuse you about some of these documents. If you have any questions, however, do well to ask me, call on me. I will drop my number on the screen flash. Do well also to comment, and we'll be very glad to follow you up. I love engaging my people, so do well to ask the questions, and I'll be glad to follow up. Thank you, and see you next time.